Okay, here is a pretty useful way to tell if someone plans on lying to you, especially in the context of business. So, the bottom line up front, if they will not put their promises in some kind of writing, then that is a high indication of a red flag. That's a high indication that they are probably already planning on breaching whatever verbal agreement they are trying to convince you of at this time. So verbal contracts are valid. They are enforceable, but that doesn't mean you're going to be able to enforce them. And here's why. When you have two parties that have mutual misunderstandings over what was agreed to, how is a judge, how is an adjudicator, whether it's an arbitrator or mediator or a conventional judge or commissioner, going to decide which of the two is telling slightly more truth than the other to meet your burden? In other words, how do you prove to the judge that since you have no more evidence than the other side, because it's a purely verbal contract, that your interpretation should be the correct one, when the opponent, usually the defendant in this case, is going to have the exact opposite argument, and they're both you and your defendant are going to both argue that your interpretation is the correct one. This is why, and this is another reason why, important agreements need to be codified in writing. So if you are meeting with a vendor, a contractor, even just someone that is loaning you something, you need to get their assurance in writing. Now, if you have a formal contract, that's great, but most of the time you don't, especially if it's an impromptu thing, especially if something that you've done multiple times before. It's never been a problem. You've had the tree trimmer come out, do the trees every year. It's never been a problem. That's one of the most common explanations as to why it wasn't put in writing. Oh, we've been doing this for years. It's always been the same. Well, if you don't have a previous writing to go on, then you're really out of luck. But even if you do, you're still not in the clear because every arrangement is going to be different. So if you are, example, in this sorry about my phone. If you are meeting with someone and they are promising you a service, let's say in this case, because I am working with a client right now who's had multiple problems with rodents at their business, they are meeting with a vendor. Hopefully there's no more rings on that, sorry. They're meeting with a vendor right now who is already the second one that they dealt with because the first one didn't give their promises in writing. And now they're saying, oh, well, we never guaranteed that we were going to get rid of the problem. We just promised that we'd show up, a few times a week. It was real vague. And I urge the client, get out now before you invest any more money. Now, one of the problems was they already paid up front. So that's another tip. Whenever you're dealing with a vendor, try to break it up into milestones. Once they have all of your money up front, do you think they're going to be more or less motivated to complete the service on time and properly, knowing that they've already been paid? So if you can break up the milestone into at least two, maybe half up front and half upon completion of a predefined, codified in writing milestone, well, that's probably going to be definitely to your benefit. And now they have a vested financial incentive to do the work and get it done on time. So if you don't have the ability to draft a contract for each transaction, which is understandable, and it's all done over the phone or in person, then at least send a follow-up email or at the very least a text message codifying the essential terms and waiting until they give you that written acknowledgement before you give them your money. Now, if they are giving you a contract to sign and it doesn't have the essential terms, like they guaranteed that they will follow up within 60 days and provide any follow-up service for free, that's not in the contract, but that's something that they told you. Well, if you have a written contract, any subsequent promises also need to be in writing. Otherwise, think about why that requirement is. Otherwise, you have a written contract and then you're supposed to tell the judge that, oh, well, even though it said that clearly in the writing, which we both signed, he told me after the fact that, oh, don't worry, I'll take care of everything. That doesn't work. You already have a written contract. Subsequent communications and variations and subsequent promises and change of orders, change of scope, those all need to be in writing as well. So again, you don't have to make this formal. You just have to have something. And the quickest way to tell if someone is bluffing when they are making you promises at the beginning of a transaction in the inducement is, are they willing to codify what they told you in person in a writing? And if they're not, then I urge you to walk away until they are willing to put that in writing, or until you can find another vendor who is. And you always need to get a second or third opinion. That's why it's always foolish to just go with the one vendor that you've always used, because there probably is someone who can do it maybe for better or cheaper or both. And if you always use the same entity, then they probably will get complacent. They probably will understand, well, he's not going to go anywhere else. I've been getting away with this level of service. It's going continually downwards. And that's how sloppiness occurs. So to recap, put things in writing at the beginning. If someone is either flaky or outright just plans on defrauding you, they're not going to put those essential terms in writing. Also, make sure you identify the first and last name of the individual you've contacted with. Make sure you have their contact information. Ideally, get their cell phone if you can. And one way to tell if they've given you accurate information, such as in a car accident right after the fact, when they're telling you, oh, don't worry. Let's just not go through insurance. I'll take care of this, I promise. I've seen this before. How gullible do you have to be after a car accident with a stranger you've never met, a person who's a stranger who doesn't want to ever talk to you or see you again, and not put their promises in writing? So one thing to do is, okay, I'm going to text you right now. You are agreeing to cover all of the damages to this car and your name, first name, last name. I have a picture of your driver's license. I'm including that in the text message. And I just need you to reply back that, yes, or I agree. Something simple as that. That'll do several things. One, you're confirming that you actually have the correct phone number, because oftentimes when people hit someone in a parking lot, they pretend to leave a note. They leave a fake number, fake name. So now you have a useless phone number. After a car accident, they tell you, oh, here's my phone number. They don't expect you to call them. They don't want you to call them. They know you're not going to verify it. So they're just gone. You're never going to reach them again. That's why if they're giving you a phone number, you call them right then, or you text them right then. And it better ring their phone. It better show that text message. And you better get a response from them right then. That way you have the confirmation that they acknowledge the terms. It's an impromptu contract right there. All right. That is going to be a valuable exhibit if this does go to civil, limited, unlimited, or small claims court. Now you have something other than what you claim they told you, which they're going to outright deny. It's hard to deny a text message from the phone number that they own with a picture of their driver's license. Are you really going to fake all that? Yeah, it's possible, but it's not probable. And when they reply back to that text message, now you have mutual consent to a written agreement. It's valuable consideration. In most cases, they're offering to pay for something in consideration of you not raising the claim to your or their insurance. So you have acceptance after the offer, you have mutual consideration, you have unequivocal acceptance of the codified terms. It's just a simple way to give yourself the, I wouldn't even say unfair advantage, just the basic prerequisites to collecting and enforcing someone's otherwise verbal and unenforceable promises. I hope you found this helpful. If you did and you like these videos, I'll make more. Thank you.